Whether the courts would be suitable as a means of resolving disputes in procurement is a matter for some debate. It can be seen as very expensive, time-consuming, but it would be difficult to foresee a different structure being put in place, and it would certainly require legislation, because there would obviously be issues of constitutionality of access to the courts if some other methodology were to be put in place. Nevertheless, I think that the introduction of the commercial court in Ireland has proved a great boon to those who wish to have procurement issues resolved quickly. There have been a number of challenges in Ireland to procurement processes, but one very recent one involved the case of SIAC Construction against the National Roads Authority, which was decided by the Commercial Court in July of 2004. Proceedings had only been instituted in around about February or March, I think, so it was quite quick. Now, that doesn't get over the expensive part of it, but as I say, I think it is difficult to envisage a framework for resolving these disputes, which is to be binding on the parties, where people will wish to have their various grievances aired as they ought to be. It'd be difficult to see that happening outside of something very much like a court. And bearing in mind that if you do have a body outside of the courts dealing with these issues, then one also has to consider whether such a body would be open to judicial review, and the question of appeal to the court would obviously have to be dealt with. So I think this is a wider topic, and one which would need some debate going forward. The question of whether an SME should take their lawyer to a feedback meeting after, or a debrief meeting after the award of a contract, I think I could answer that by saying, no, I don't think they should. The presence of a lawyer on behalf of the SME would create, I think, a totally different aspect or attitude in the room if he's present, because I think that the public sector body would be less likely to be open and frank in terms of the answers that they would give to the questions. I think they would be, they'd be nervous, I think, of having a lawyer there, because, to be fair, it suggests that really the purpose of the meeting is to get information to mount a challenge. Whereas, in fact, the SME may, more often than not, simply want to know why did they not get the contract, so that they can say, well, okay, maybe we can do better here or there the next time round. So I think that the SME's first port of call really is to look for a debriefing, and to look for that very quickly. They can write or pick up the phone and ask for the debriefing, bearing in mind that there is no legal obligation on the contracting authority to offer a debriefing meeting. All that the contracting authority is required to do is to give certain reasons in writing within a certain time period. But more often than not, contracting authorities are happy to give a debriefing meeting. And arising from that meeting, if the SME feels that something is amiss, then I think that's the time to be talking to their lawyer. They could, of course, talk to their lawyer before they go to the meeting and be armed with some of the questions that perhaps they should be asking. And then arising out of that, then they can decide whether there's a challenge to be mounted or not. Where the directives don't apply, there are still principles which must govern the award of a contract. These are derived from the Treaty of Rome itself. That's the treaty which set up the European Union originally. And those principles are fairness, proportionality, transparency, equal treatment. And even if the directives don't apply, sub-threshold, for example, then the contract procedures must honour those principles.